This is a combination hearing on case number 20-00096, Yvonne Black versus Jocelyn Benson as Secretary of State. Case number 2091, Nevin P. Cooper-Keel versus Michigan Secretary of State. And case number 2099, Robert Davis versus Jocelyn Benson in her official capacity as Secretary of State. If counsel can be brought into the room so that they can state their appearances for themselves as pro ses or on behalf of their clients.
I'm sorry, Judge Stevens?
Yes.
As you were saying, if can counsel be brought in, somehow I was clicked out and then brought back in. So I don't know if you said anything outside of that.
No, ma'am, I did not. Thank you.
Thank you.
Okay. Counsel, if I understand that two of you will be available, well, several of you will be available by video, and that one of our participants will only be available by audio.
Correct, Your Honor. Robert Davis, case number 2099 MM, pro se plaintiff.
Okay, we're waiting for. Okay, we have one more counsel to appear. And I would ask those counsel who have been admitted to please reveal yourselves if you would. I understand that Mr. Davis we will not be able to see him. Ms. Black?
Yes, Your Honor, I'm sorry. I'm just, yes, Yvonne Black proper.
Okay, I was just waiting for everybody to get here. Mr. Grill, is your colleague joining us today or is it just yourself?
I believe she might have been called away at the last minute. She may be joining as we proceed, but I will be the one conducting any argument today, so we can proceed if you wish.
Okay, so I have previously indicated what the cases are that we were hearing, and we'll start out with the first case, which is 91, and 91 is the case which is entitled Nevin P. Cooper-Keel, JD versus Michigan Secretary of State. Mr. Cooper-Keel, could you state your appearance for the record?
Yes, Your Honor. My name is Nevin Cooper-Keel, appearing pro se.
We additionally have as 96, Ms. Yvonne Black versus Jocelyn Benson. Ms. Black, could you state your appearance for the record?
Yvonne Black proper.
And the final case for this morning, Robert Davis, pro se versus Jocelyn Benson, number 99. Could you state your appearance again, Mr. Davis?
Yes, may it please His Most Honorable Court, Robert Davis, pro per.
And then on behalf of the Secretary of State in all three cases, if you would state your appearance, sir.
Good afternoon, Your Honor. My name is Eric Grill. I'm with the Michigan Department of Attorney General, appearing on behalf of the Secretary.
Okay. Counsel and parties, I would indicate to you that Ms. Mapp is our court reporter. She has the task of, despite whatever the technology gods do, trying to record each and everything that is said while we are in session. To that end, at any point in time, she may interrupt any of us, myself included, to indicate that either she was thrown off of the conference, that she could not hear what was being said by a person who was speaking, or that she did not understand what was said because the sound gets distorted. At any point that she does that, as soon as I'm aware of it, I will make counsel aware of it and give you the opportunity to repeat whatever it was that was being said. I'm going to ask, so that we have the best opportunity to have a good record, that everyone be muted until it is their time to speak. I have a preliminary matter, and it is the request to file an amicus curiae, which was filed by the Brennan Center. I was informed that this request was one where they had sought the acquiescence of the parties and where the defense had agreed to the amici, but the plaintiffs had not. I'd indicate now that Ms. Meingast is here, and if you wish to state your appearance, ma'am. If you unmute,
Thank you.
state. Yes,
Thank
ma'am.
you. I'm sorry. Thank you, Your Honor. I am also appearing on behalf of the Secretary of State, although Mr. Grill will be doing the arguments today.
Absolutely. But since you're here, we should explain to those who are watching why you're here.
Thank you.
Okay. So, Ms. Black, have you had the opportunity to see the proposed amicus curiae filed on behalf of the Brennan Center?
No, I have not, Your Honor.
Okay, it was filed to, well, I got it this morning at 11:10. Did they make contact with you?
Not that I'm aware of, Your Honor. I was, not that I'm aware of. I haven't checked my phone. If they contacted me by phone, I haven't seen anything by email. I've been very busy focusing on this morning's argument. I apologize.
Not a problem. Mr. Cooper-Keel, did you receive a copy of the proposed amicus?
No, I did not, Your Honor.
Mr. Davis?
Thank you, Your Honor. And yes, I did receive a call and I received a copy of the brief, and I could not return his call due to handling funeral matters. And I do not oppose the filing of the amicus.
Okay. Our condolences for whatever funeral matter that you had to manage. Okay, so counsel, I'm in receipt of the amici. As you know, that doesn't make them a party. It would merely afford them the opportunity to share their position. Their position on behalf of the Brennan Center is, in point of fact, in fairly significant alliance with the position offered by the Secretary of the State. What I will do is as follows. I do believe that the amici is in some ways useful, but I do believe that you are entitled to respond to it. I will accept it as an amicus brief, and to the extent that you have comments that you want to make to the things that are said in that brief, I would ask that you present them to this court no later than Thursday of this week. They need not be in a formal brief kind of fancy thing. It can merely be entitled memo in response to amici. Do you understand, Mr. Cooper-Keel?
No, Your Honor. I'm sorry. I've been disconnected from this meeting several times. I just switched my internet connection to a different channel. Hopefully it's going to be good now. But I did receive a call, and I told them, you know, I would oppose it because, and I'd like to get into kind of the dirty tricks the AG's office has played so far with avoiding service. But when they got a team of taxpayer-funded attorneys playing dirty tricks.
Mr. Cooper-Keel, here's what we are going to do here. We're going to all address the issues, not the character, habits, or routine of the party whom we are opposing. So while I understand that you have some concern about service, the issue that we were addressing right now was my saying that I understood I did not get the proposed amicus brief until this morning. I did have the opportunity to review it. I believe I am prepared to accept it. However, I was indicating that I would afford any party who was objecting to it, and frankly, even Mr. Davis, who isn't objecting, the opportunity to give me something that would be called simply memorandum in response to amicus that would address whatever issues in the amicus that you think deserve addressing in writing. I would like to get that by Thursday of this week. The amicus isn't that long. Formal brief.
Your Honor, if I may interject,
Yes, Mr. Davis.
is it okay that we do the filing via email to the clerk of the court?
The way that you can do an e-filing with the clerk of the court. However, with the clerk of the court of claims, not the Court of Appeals. However,
Correct.
as was noted in some earlier orders, I'm not going to get that directly. So there is also a process, and everyone, I hope, was given the email of my judicial assistant, and you can mail an electronic copy to her. In any case, when we conclude this hearing, there will be an order that will go to you along with an electronic copy. If we have your email addresses, we will send an electronic copy of the proposed amicus brief to you. We will send a copy of a notice of the date by which the amicus brief response, if any, needs to be filed, and the courtesy copy address that goes to Ms. Lockhart in my office. So just in case got lost, somehow you didn't get it, everyone will get the same kind of notice. Do you understand, Ms. Black?
Yes, Your Honor, I understand. Thank you.
Okay, Mr. Cooper-Keel? Do you understand
Yes,
our
I
process?
understand, Your Honor.
Okay, and Mr. Davis, you're clear on our process as well?
Yes, Your Honor.
And finally, on behalf of the AG.
Yes, Your Honor. Thank you.
Okay, so what I am going to do is do this in order of when the case was filed, not when it was served. And so the first person who will have the opportunity to make their statement in support of their request for relief will, of course, be Mr. Cooper-Keel. Mr. Cooper-Keel will be followed by Ms. Black, and finally by Mr. Davis. I would ask, unless there is some vehement objection, that the Attorney General respond to all three in a singular response. Are you comfortable with that on behalf of the Attorney General?
Yes, Your Honor.
Okay. That means that once he has made whatever comments he deems appropriate, each of the plaintiffs will have a brief that starts with a capital B. It ends with an F. It's in bold and it's underlined 3 times. Opportunity for rebuttal. Rebuttal not being repeating the points that you thought were strongest, but addressing those points that you did not have the opportunity to address in your initial statements. With that, we begin, please, with Mr. Cooper-Keel.
Thank you, Your Honor.
And all the rest of us except me would be muted. Thank you. Yes, sir.
Okay, Your Honor. So I filed my complaint and my motion for, I think today we're just here for the preliminary injunction question, within a couple of days after the press notice from the Secretary of State that they were going to be sending out unsolicited absentee ballot applications. And I mean, I think I covered a lot in the writing of it. I just received the Attorney General's 31-page brief yesterday. I finished up reading that about an hour before this hearing. So it's, I mean, there's a lot of objections I want to make to that. I mean, they didn't even answer my complaint. They said, though, it was a illegible 8-page complaint, and they sent me a 31-page brief a day before this hearing. But to not re-go over the things I wrote, I'd just like to talk about the things going on. I mean, they're claiming, as far as what I can see in their large brief they sent me yesterday, it's justifiable because of this pandemic emergency, and that's really, I think, kind of disingenuous. Because I spoke to one of their staff June 5th when I was trying to serve them with this, after I'd already sent a process server there once. I had her on the phone and I said, hey, you think I can just serve you by email? You know, they're rogue government agents operating behind closed doors. They're operating to accept service. It's not that much of an emergency. They'd accept service by email. And sure, they have plausible deniability that they were just, you know, protecting their rights or whatever. But to me, it seems kind of disingenuous. They need to engage in statewide voter fraud, which is established many times by this court is illegal for them to do. And yet they wouldn't even accept process of my filing by email. So right off the bat, I kind of find them a little bit disingenuous with that argument. But I guess just to get to the notion of the two cases, my filing relied on, Taylor and Fleming. The notion behind those cases is actually, I kind of find to be the same notion that some of the protests going on right now follow. And I don't agree with everything going on with the protests, but I think at the heart of them, one thing I do agree with is that, you know, if you want to be just a private corporation or a private individual, you got pretty lax standards, ultimate freedom. But if you want to be a civil servant, getting paid by taxpayer dollars, you ought to conduct the Secretary of State is not a private corporation to be run as Jocelyn Benson pleases. There's rules that they have to follow, and they're not following them. And I think that's kind of at the heart of these protests about police brutality. It's that, you know, if you want to be a civil servant and receive higher than average private pay, higher than average benefits of a private sector employee by working with the government, you need to hold yourself to a higher standard of conduct. And my impression with, you know, they can engage in statewide voter fraud and yet not even accept service through email from me, I don't think was necessarily even living up to the same standards they're saying justifies what the Secretary of State is doing. And I think really gets to the heart of what the Fleming and Taylor cases were based on. And that's that, you know, if you want to send unsolicited political mailings, do it on your own dime. Don't use the taxpayer dime to go give yourself a pat on the back and say, ooh, the hysteria, look, we're taking care of you, vote for my party. That's what it boils down to. That's why it's ill. And just to kind of hit a couple other points they said in their thing, you know, it's hard just in a less than 24-hour period for me to really even have had time to understand them. But I think what they're saying is it's okay for the Secretary of State to do this, even though in Taylor and Fleming, the court explicitly said the action of a civil servant using their government office to use taxpayer resources to send out unsolicited political mailings amounts to illegal propaganda. They're saying it's okay because the Secretary of State is a higher position. And even though the election law that those cases were based around has not been changed in Prop 3, Prop 3 didn't do anything to change the process of voting by absentee ballot. It didn't do anything to say, hey, now we're going to just send you unsolicited absentee ballot applications. None of that has changed. None of the law that those two cases were based on has changed. None of the context around it, even with Prop 3. It didn't say anything to change the process, which ultimately is in the hands of local clerks. The motion, they say, well, she's the chief election officer in a supervisory capacity. So it's okay for the Secretary of State to not just step in and take over local clerks' roles, which are clearly delineated in the election law cited in those cases and in my complaint. It's okay for her to step in and take over their roles, and also to invent laws and new processes because there's hysteria right now. And it's okay to not follow the law and just follow hysteria, which in another just saw come out, this Michigan Supreme Court said, actually, no, we shouldn't be following hysteria. We should be following law. And so that's, I think, what this boils down to too. A pretty much identical issue to that one with the barber. The Secretary of State's trying to use hysteria as a pretext to violate the law. That's what this boils down to. They didn't really say anything to counter that from what I saw. So not to drool on, I think I'll probably leave it at that. This is, right now, just for the preliminary injunction, they've already been doing this, unfortunately. That doesn't make it okay. Simply the fact of breaking the law and nobody stopped him yet doesn't mean it's any different than breaking the law. So.
Okay, so
I'm
I want to
asking
look at your
the-
prayer for relief, if I may. You
Sure.
asked that we enjoin the Secretary of State from mailing the applications. Of course, we can't do anything about those that have already been mailed. You then say, enjoin the Secretary of State from using that political office to direct state resources to advocate other clerks violate the law by sending unsolicited absentee voter applications. I'm not exactly sure what that means.
Thank you for bringing that up, Your Honor. Well, I've noticed they're not just in some of the press releases that have come out from the Secretary of State, it appears they're saying in locales where they can get a local clerk to send these unsolicited absentee ballot applications, they're going to try to skip sending them in those areas. And then in other areas where local clerks are like, what? No, this is illegal. The Secretary of State's going to send them on behalf of those clerks, which I mean, I could almost see in the sense of their supervisory capacity, if it were legal for clerks or anybody in public office to be sending unsolicited political mailings, that would be okay. But it's not okay for any public official to be sending unsolicited political mailings, which is why they don't have the right to do it themselves or direct local clerks, because that's the message the local clerks have been getting from the Secretary of State, is that the Secretary of State wants them to send unsolicited.
Okay, there's a difference
political
between
mailings.
saying, I'd like you to do it and directing. So you want me to preclude them from directing them to do so. Is that correct?
Yes, that would be correct.
Okay, I think I understand. You also ask for reasonable cost and per fees. You understand that all that you would recover would be your filing fees and your process server fees?
Well, I mean,
You're not
I don't know about,
you're not an attorney, so you can't get attorney's fees.
I'm not asking for attorney's fees, but I don't think that's really what I was prepared to discuss today. But no, I think there's other case law that supports not just attorneys getting paid for their time if they're forced to engage in litigation.
I'll tell you that you actually have to be prepared to discuss it if you asked for it. So I am unclear as to any court rule that would authorize more than, at this point, your filing fees and your process server fees and any copying fees. I'm not aware of anything else. So I look forward, whenever you respond to the amicus, that you share your court rule or authority for that requested relief, if you have any. Okay.
I would
Thank
like
you
to,
very
Your
much.
Honor. If I
Ms.
could,
Black. Yes. Weren't you done?
I was just going to say, after getting their 31-page brief less than 24 hours ago, it's been a struggle to be prepared for this hearing. I mean, it's really, in that sense, kind of unfair to me. This hearing needs to be had, so I'm not saying I want to object to this hearing, but in my defense, it's been a rough 24 hours.
Well, we don't have a third option here. Either you object because this hearing is not timely and we give you another hearing date, or you waive the objection and we go forward.
Well, I'm waiving it as far as this hearing, because my understanding is this is just regarding a preliminary injunction, and we will have a hearing on the full merits of the question. Is that correct?
Yes, sir. That is what a
Okay.
preliminary injunction does. Yes, sir.
Yes, for this hearing, I'm waiving
Okay.
anything as far as this hearing.
Thank you. Ms. Black. Please unmute and share with us why your prayer for relief should be granted.
Thank you, Your Honor. The reason I filed is because the actions are unlawful. And I will suffer irreparable harm, and so will every other elector in Michigan, absent an injunction. The mailing of unsolicited absent ballot voter applications is in violation of MCL 1687592, which states the elector shall apply in person or by mail with the clerk of the township, city, or village in which the voter is registered. In Article 2(4)(g) of our Michigan Constitution, the right, once registered to vote as an absent voter ballot without giving a reason, and the right to choose whether the absent ballot is applied for in person or by mail. So I'm being denied, or actually we're being forced to participate when I receive things in my mailbox, when the laws direct me and the Constitution directs me opposite of what the Secretary of State's actions are.
And what is your irreparable harm, ma'am?
That the right to choose is violated and void in this process. Because number one, the law or the Constitution does not afford any entity to broad form mail absent voter ballot applications. The law is specific on how, and going back to Article 2(4), except as otherwise provided in this Constitution or in the Constitution or laws of the United States, the legislature shall enact laws to regulate the time, place, and manner of all nominations and elections, to preserve the purity of elections, to preserve the secrecy of the ballot, to guard against abuses of the elective franchise, and to provide for a system of voter registration in absentee voting. And so to keep it pure, to keep it with integrity, we have our constitutional amendments, we have our legislated laws that govern how this is to be done. And in reading Secretary Benson, it was an interesting, she opines the Michigan election law does not expressly prohibit the mailing of absent voter ballot applications by the Secretary of State. And so that action is consistent with her broad authority granted to her. Well, I would disagree with the US Supreme Court 1872, Raleigh and Gadsden. When a statute limits a thing to be done in a particular mode, it includes a negative of any other mode, which expressly opposes defendant Benson's opinion that because nowhere in the law, nowhere in the Constitution does it say that she can't do it, but it doesn't say that she can either. And it expressly states, the law expressly states, the elector shall apply in person or by mail with the clerk of the township, city, or village in which the voter is registered. So when the law tells me this is what I shall do, and an elected official who thinks that she has broad authority, which is not granted to her in our Constitution or in our statutes, to go against what I as an elector am being told is legal, what our local clerks are being told is legal. And when you talked about the harm, okay, so this action is detrimental to our democratic election processes and makes devoid the elector's right to choose, setting precedents for the Secretary of State or any future Secretary of State of permanently altering Michigan's current absent voter ballot application process without legislative action or constitutional amendments as compulsory in the 1963 Michigan Constitution. So an elected official deciding that they can just change the legal and constitutional process and then mass mail. And so then why can't anybody else mass mail? And so then we have hundreds of mass mailings of absentee voter ballot applications circulating in our communities, coming to our mailboxes, when our Constitution specifically states that I have the right to choose. And so it's very
You don't,
contradictory.
okay, you don't mean the Constitution, you mean the
No,
statute?
the Constitution states. The Constitution, Article 2(4)(g). The right, once registered to vote, an absent voter ballot without giving a reason. The right to choose whether the absent voter ballot is applied for in person or by mail is expressly stated in the Constitution. And so the vote, to vote an absent voter ballot without giving a reason does not change the process of applying for that application.
I understand your argument.
Pardon?
I said, I understand your argument.
Okay. So I feel that this is detrimentally harmful to our election processes. It's harmful to me because I'm directed by the Constitution and the laws of how I shall apply. And that shall apply is directly to, and then there's various ways to apply to my local clerk, my township clerk. I can go in person, I can send a letter, I can call them up and ask them for an application.
I understand, ma'am. Is there anything more that you want to highlight, or can we hear from Mr. Davis?
I think that's pretty much
Okay.
the main concerns I have in this violation of our Constitution and our statutes.
Thank you very much. Mr. Davis?
Thank you very much, Your Honor. My action is somewhat similar, but somewhat different from the previous two cases in which the court has just heard oral arguments from. The currently before the court is my emergency motion for declaratory judgment pursuant to NCR 2.605D, and I want to thank the court for advancing this motion upon the court's calendar to hear it on an expedited matter. Just for clarification, with respect to my request for a motion for declaratory judgment, I did not request injunctive relief because pursuant to the holding of the Michigan Court of Appeals in Davis versus Detroit Financial Review Team, 296 Mich. App 568 at page 614, quoting Strauss versus Governor 459 Mich. 526 at page 532, 1999, a request for declaratory judgment or declaratory relief normally will suffice to induce the legislative and executive branches to enforce the law as it is written. So with respect to my case, Your Honor, I am only respecting declaratory relief, and in accordance with the holdings of the Michigan Supreme Court in Strauss versus Governor and Davis versus Detroit Financial Review Team, that should suffice with respect to the relief I'm requested. Based upon the response of the Michigan Secretary of State, they are not contesting my standing to bring forth this action. And so I believe that the standing principles with respect to this election-related cases are pretty much clear that an elector does in fact have standing to seek the enforcement or make sure that the election laws of the state are properly adhered to. In addition, to fulfill the declaratory judgment requirements under the Michigan court rules and the standing requirements of Michigan jurisprudence, there is an actual controversy that exists as a result of me receiving an unsolicited absentee voter application at my home address from the defendant Secretary of State on Wednesday, May 27, 2020. I would like to inform the court that a separate action is also pending in Wayne County Circuit Court against the Detroit City Clerk based upon her unilateral actions of mailing unsolicited absentee voter ballot applications and being in violation of both the Wayne County Circuit Court standing order that was issued in the well-cited case of Taylor v. Curry, based upon the instructions that she was given from the defendant Secretary of State. Your Honor, with respect to my request for declaratory relief, there's, based upon the arguments that were just made by the two plaintiffs in the two previous cases, it's quite clear that my nervousness is a real one. Here you have individuals from across the state that are truly concerned about the Secretary of State's actions. And this may call into question the legality of this upcoming primary and general election. As I cited in both my complaint and motion, the actions of the Secretary of State may well bring about actions in the form of quo warranto challenging the legality of both the primary and general elections. The law is quite clear, and the Counsel for the Secretary of State goes in great length to try to make the argument that the Secretary of State has broad powers under Michigan election law, and I would respectfully disagree. As a member of the executive branch as cited in my motion for declaratory relief, the Secretary of State only has the powers as prescribed by law. The Michigan legislature enumerated the powers of the Michigan Secretary of State in MCL 168.31 of Michigan election law. There is no provision within MCL 168.31 or within any other provision of Michigan election law that grants the Michigan Secretary of State the authority to mass mail unsolicited absentee voter applications to register voters. And I applaud the Secretary of State for her actions because in light of the pandemic. However, all of us have to adhere and comply with the law. With respect to absentee voter applications, the Secretary of State has never had any role with respect to issuing absentee voter applications, nor issuing any absentee voter ballots. As the Michigan election law clearly states, MCL 168.759 subsection 5 grants that exclusive authority to the local clerks in both city, townships, or villages. And in Taylor v. Curry, the Michigan Court of Appeals made it very clear that local clerks and township clerks and village clerks do not have the statutory authority to mail unsolicited absentee voter applications. That's well settled. And in the unpublished opinion in Fleming, the court went further to say county clerks do not have the statutory authority. Here, similarly, the Michigan election law, nor the duties enumerated in 168.31, gives the Secretary of State the authority to mail unsolicited absentee voter applications to registered voters. Although her intentions are well intended, she cannot circumvent the law in order to get this accomplished. And in her goodwill, she's creating a situation where now both elections, both the primary and the general, are going to be subject to challenges. And certainly from the commentary given from the two plaintiffs in the two previous cases, that's abundantly clear that that's coming down the road as she's allowed to continue these actions. The phrase prescribed by law. Oh, yes.
Mr. Davis?
Yes.
You made your argument that there is jeopardy for both the primary and the general a couple of times. So I'm hoping that if there's an additional point that you want to highlight, other than those which you have written about and addressed, you get straight to that.
Yes, Your Honor. The one area in which I would like for the court to pay keen attention to is in accordance with the constitutional provision set forth in Article 5, Section 9, which states that single executives heading principal departments perform duties prescribed by law, that there's ample case law with respect to similar language with the phrase provided by law. And I will direct the court's attention to Shin versus Wayne State University, 284 Miss Act 172, 2009, as well as King versus Oakland County Prosecutor, 303 Miss Act 222, 2013, as well as the case of Dower versus Zabel, 9 Miss Act 176 at 180, 1967. And basically, Your Honor, is that the statute that enumerates the powers and duties of the Secretary of State has not prescribed the Secretary of State the authority or the duties to issue unsolicited absentee voter applications. And I thank you for your time, Your Honor.
Thank you very much, sir. And in response to the arguments of all three plaintiffs.
Thank you, Your Honor. I know the court has read the briefs and certainly has then already seen the arguments we've raised in varying forms at least 3 times. So I will spare the court a 4th recitation and limit my remarks to the things specifically raised this afternoon. In regards to the argument raised by Mr. Cooper-Keel, respectfully, Proposal 3 did change things. It is no longer a matter of statutory privilege to vote absentee. It is now enshrined in our state constitution, and every registered voter now has a constitutional right to vote absentee without having to provide any reason. That changes the landscape of the election process, I think, rather significantly. Is this something that we didn't have before, and certainly wasn't present in either the Taylor or Fleming cases. And then as far as the Secretary of State's role as the chief election officer in providing guidance to the clerks on the proper methods of conducting an election, I don't think it is much of a stretch to say that mailing out these applications was in furtherance of that objective and in support of the people's right to vote absentee if they so choose. Regarding the arguments raised by Ms. Black, I still don't think I quite understand how she or anyone else will be irreparably harmed by having received an application in the mail. Certainly this doesn't change any of their substantive rights, and it doesn't change their approach in going forward with this election. And I wish to emphasize that there has been no loss of choice by any voter as a result of these applications. You can still apply however you want, whether you want to use these applications provided by the Secretary of State or an application provided by some other individual or group, or whether you wish to make your own written request, or whether you wish to go in person to the clerk's office. Those options are still available to every single voter. They can still choose not to apply to vote for absentee if they so choose. You can still go to vote on election day. All of those options remain in front of you. This was merely one way of effectuating or offering people an option if they chose to avail themselves of it.
Counsel, this self-executing provision of the Constitution providing the right to vote by absentee ballot without a reason, what is it about the language there that you believe modifies the portions of the Constitution that afford to the legislature the responsibility of determining the time, manner, etc. of elections, including their fairly detailed determination of how absent ballot applications should be obtained?
Well, respectfully, Your Honor, I think there's 2 layers there. First, as regards to the subsection G of Section 4 of Article 2, the part that I would pay particular close attention to would be the section right below G, kind of at the end of Section H, where it says that this section shall be liberally construed in favor of voters' rights in order to effectuate its purposes here. The purposes of this amendment was to make sure that every single citizen, every registered voter in the state of Michigan had the opportunity to vote absentee if they wish to do so within the time and the ability to provide it. This mailing of an application, and that's all it is the mailing of an application. The ballots come later if they make themselves available, if they want to submit the application and ask for one. This is simply just providing people a mere piece of paper with which they can use to avail themselves of their new constitutional right. Looking at the election law, for as much as we hear about violations of the law, there is nothing in the election law that prohibits the Secretary of State from doing this. There is a lot of trying to suture together the Taylor and Fleming arguments to say, well, that represents an absolute bar. I don't think that's the case. You can certainly look.
Counsel, there's some rules of legislative construction, right? So what rule of legislative construction where we have a piece of legislation which says you get an absentee ballot by doing one of 6 things, 3 things, whatever. What rule of statutory construction would say that in addition, you get a ballot by another thing? Give me that rule.
All right, Your Honor. Well, again, the Michigan election law provides the clerks make the applications available in particular ways. It doesn't say anything about the secretary not making the applications available.
I know what it says. I'm asking you, remembering that we've got these rules of statutory construction.
Yes.
Listing one thing, rather than pretending that we can all speak our high school Latin. The listing of one thing is implied to exclude others. Why does that not apply here?
We raised this point in our brief, Your Honor, and certainly I would rely to a great extent on that section of the argument, but I think what we look at there is, if you take that to its logical extreme, then anything not specifically written in the election code somehow falls below or falls into the category of violation. And for all of the various circumstances we identified in our brief, not the least of which, the one that comes to mind is the idea that the statute says we can only provide pencils in the voting booths. If we take that to its logical extreme, that, well, that means that's what it says, and anything not in the statute is prohibited. We haven't used pencils in the ballots for several elections now. We've gone to those little felt markers or the pens that you use to mark the ballots. So if we're going on the principle that, well, that's prohibited, all kinds of actions and things that take place on the minuscule, the administrative level of administering an election becomes prohibited. And that leads to an absurd result. And I believe that's the principle of construction.
So if we take, but that's, I appreciate advocacy at the extreme, because you know that what we're going to hear from your colleagues is, well, pencils, okay. If we take it to the other extreme, almost anything you do that aids in getting an absentee ballot, therefore is legal. I don't think that, do you think that we go to the extreme either way?
I guess, Your Honor, I struggle mightily with the idea of trying to figure out what one could do with an absentee voter ballot application in such a way that renders it excessive or illegal in some way. Ultimately, the application is just that. It's a piece of paper that people can either use or not use if they want. But it's not taking anything away from anyone. It's not depriving anyone of their ability to vote. It's not really changing the landscape for anything other than simply, I guess I would analogize it to, if we make this application available on the Secretary of State's website, what meaningful difference is there between that action and mailing an application to people's homes? We're still making the application available. People have the ability to use it if they so choose, and mail it if they so choose, or take it into their clerk's office if they so choose. This is a matter of administering and providing supplies to the voters for which they can use to exercise their right to vote. I certainly see anything in the text of 759 that precludes her from doing that. I think that the rules are floors rather than ceilings. And again, I would point to if the court's asking for a principle of statutory construction, we quote in our brief section talking about reading statutes in such a way as to not reach absurd results. And certainly I think the position offered by the plaintiffs in this case does just that. Lastly, turning to Mr. Davis, I still see no basis to dispute or challenge the election results on the basis of anyone having received an application. They still have to be a registered voter. They still have to fill out the form correctly. They still have to fill out their ballot correctly. There's no basis for there to be a challenge on material fraud or something else to say that the results of the election are somehow cast into doubt. The only thing that could ever or would ever happen is registered voters voting. As a regards to standing for Mr. Davis, I guess a lot of things have happened here in the last week. I would certainly say that there's nothing in our brief, I think, that precludes us from saying that the same reasons we argue that Ms. Black is not entitled to a declaratory judgment would apply with just as much force to Mr. Davis, in as much as failing to raise an actual claim or controversy upon which this court could base a declaratory judgment. I certainly think that there was nothing that would stop the court from reaching that conclusion. With that, like I say, I know the court has read all of the briefing, and I know that the court's well apprised of the issues. If the court has any other questions, I'd be happy to try my best to answer them.
I don't have any more. Thank you.
Thank you, Your Honor.
So, Mr. Cooper-Keel, in brief Brief rebuttal.
Yes, Your Honor, thank you. I will be brief. Took a couple notes on what he said. I mean, he just compared the absentee voter ballot process to difference between a pen and a pencil, which is quite an understatement. The reason the absentee voter application process is delineated the way it is in our laws is because we have an interest as a democracy in encouraging in-person voting. And there are reasons. He just said there's no risk of fraud. There's people getting, people that are deceased getting these applications, people that are no longer at these addresses. The reason we have an interest in encouraging in-person voting is because it's more secure. You go in person, you take your ballot, you stick it in a machine. It's supposed to be slipped straight into a locked box that doesn't get unlocked until, election night, they need to recount the ballots or something.
Well, except
Absentee-
Mr. Cooper-Keel, we at this point have an interest in our Constitution in having qualified electors vote. There is no preference now in our Constitution as amended by the people for in-person versus absent ballot voting. There is a preference and a provision that highlights that we should assure as best we can that qualified electors cast a ballot. That's it. The argument that you pose in this regard prior to the amendment would have had some traction. It may be your policy provision, your policy analysis that's better, and you might be right. But the people at this point have voting and no question absentee voting right there together. So the people have not established a preference one for the other. The people's preference is the part that you're addressing, which is that qualified electors be the individuals who vote.
No, Your Honor, I would disagree with that.
Well, good.
The only thing Prop 3 changed is that, I'm sorry. Okay.
I mean,
the only thing Prop 3
disagreeing is
changed.
probably, okay. Yes, sir, finally.
Okay. The only thing Prop 3 changed is it expanded the people who are allowed to vote absentee, and that's cool. If you really need to vote absentee, everybody can do it. But it has not changed the process in any way, shape, or form of voting absentee. And the reasons behind that are because we still want to encourage in-person voting over absentee voting. We've expanded absentee voting because we want everybody to get a chance to vote. But if they can make it in person, we have an interest in them doing that because it is a more secure way to vote. And it's less taxing on our democracy for them to do it, not just literally as far as the amount of money it costs, but it's more secure. So that's it.
All right, I understand. Ms. Black. Yes, ma'am.
Thank you, Your Honor. So I would like to go back to I'm sorry, 168, MCL 168.31 for the conduct of elections and registrations in accordance with the laws of this state. So I'm sorry, I've lost my spot here. The defendant, Jocelyn Benson, will continue to exercise power to which he is not entitled. An action which directly infringes, I'm sorry, what?
I was going to say, the things that you wrote down, I've really read. Is there a point, and you did write that down, and you did address it, and you addressed it in your initial argument. Is there anything that that the counsel for the defense addressed that you think you didn't get a chance to talk about in your brief?
Sure, Your Honor. I would agree with Mr. Cooper-Keel about comparing following election laws to pens and pencils and hand sanitizers in the room. That's just a little, that is absurd if we want to use absurdities, but
Okay.
So I guess that would be all for me, Your Honor.
I appreciate that. Anything that you feel compelled to share, Mr. Davis?
Yes, Your Honor. Very, very briefly, I would just like to address counsel's comment regarding the absurd result. This court is well aware of the rules of statutory construction as being a jurist on the Michigan Court of Appeals. I would just like to turn the court's attention to Barrow versus Detroit Election Commission, in which the absurd result rule was addressed, in which the Court of Appeals stated the following. Our Supreme Court, however, has commented that the absurd results rule of construction typically is merely an invitation to judicial lawmaking and is totally not adhered to. It's the words of the statute that the courts must enforce, and they must enforce it as written. And that's cited in Barrow versus City of Detroit Election Commission, 301 Mich. Act 404, 2013. Additionally, lastly, counsel made a remark with respect to the declaratory relief and actual controversy. One of the prayers for relief in which I was requesting is that as an elector, I'm in flux as to whether or not this application that I received at my home will be accepted by my local clerk, which has not stated affirmatively whether or not they will be accepted. And one of the prayers for relief is seeking this court's declaration of whether or not the applications that we did in fact receive can be used and turned in to our local clerks. So certainly, in addition to the other arguments made, all the elements of declaratory relief have been met with respect to my case. And of course, as the Secretary of State has admitted, standing has not been questioned.
Okay, the case will be submitted for review. Again, the plaintiffs have the opportunity to address the brief filed by the Brennan Center no later than Thursday at 4 p.m. All parties have agreed to accept electronic service. Is that if anyone objects to it, speak now. No one. So all parties have object.
I object, Your Honor. I
You
object.
don't want electronic, excuse me. You're not going to accept electronic service?
No, just like they wouldn't accept
Okay.
electronic service and made me send the
Here's
process
what you
server
need to
twice.
understand, therefore, that no communication in this case, other than the direct communication by the court, which is going to come to you by electronic service. You're not going to really get a choice on that one. Will have to be done by mail, which will increase the time for managing this case. So the plaintiffs will have the opportunity to address the brief filed by the Brennan Center no later than this Thursday at 5 o'clock. Since Ms. Black, are you accepting electronic service?
Yes, Your Honor, that would be
Okay.
fine.
And Mr. Davis?
Yes, Your Honor, I'm accepting electronic service.
Okay. They'll be filed by 5 o'clock on Friday. The challenge and Thursday rather. The court will take the matter then under advisement and issue an opinion no later than 10 days from the date from Thursday. We have an interesting situation here. We invited Mr. Davis here because we were going to talk about the case, and we figured he ought to be here because we were all talking about the same issues. However, he has, as he noted, no request for injunctive relief. I do not know the extent to which the defendant, whether injunctive relief is granted or denied, intended to file additional papers, which basically would amount to a motion for summary relief as relates to all three cases. Or were you going to rely on the pleadings and papers that you filed thus far for the ultimate relief? I suspect not.
Your Honor, it has been something of a chaotic time here in the last week, especially with these particular three cases. It is our intention, I believe, to move to dismiss the cases largely for a lot of the reasons we've argued of the legal insufficiency of their pleadings and the claims being raised before this court. We can
So the
have,
answer to my direct question is, you would intend to file additional papers in this case prior to the court ruling on the ultimate claim for relief?
we can file a motion to dismiss in all three cases, Your Honor. Yes.
I'm not inviting a motion. I just said, were you likely to be filing any additional papers as to the ultimate relief? And the answer is yes.
Yes.
Okay. That means that obviously, Mr. Davis, as relates to your case, there will be no ruling on your ultimate case request for relief. And the court will have to issue an additional scheduling order that would state the dates by which any or all parties can move for the ultimate relief requested or dismissal before this court. So I will set a schedule for that as soon as I have a chance to actually think about it. I find that the top of my head is not necessarily the best portion for making rational decisions. So you will get that order from the court probably within the next day or two. With that, the matter will be submitted. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
Court is adjourned.
Thank
Thank you,
you.
Your Honor.